All right, good afternoon, everyone, and welcome to today's webinar. My name is Jorge Acosta Palmer, and I'm the director of the Statewide Training Initiative with Florida Legal Services. We're excited to have you join us for Elder Exploitation in Practice, Legal Remedies, Prevention, and Advocacy Strategies. Before I introduce our amazing speaker, I do want to go through some quick housekeeping announcements. This training is being recorded, so if you registered, you're going to receive a copy from Zoom within about 24 hours with a link to the recording, a link to the materials, the CLE information, and everything else. If you didn't register, we will also be posting it on YouTube. So if you want to share with others, make sure to share that link, the YouTube link, in the YouTube description. I will also include the CLE information, the link to the materials, and everything else that you need to know about the webinar. This training was approved by the Florida Bar for one General CLE credit and one Elder Law Certification credit. I'll announce the CLE code towards the end of the session. I will drop it into the chat, and it will also be included in the email from Zoom and in the YouTube description. Closed captions are enabled for anybody who needs them. So if you're having any issues with accessibility or closed captions, feel free to let me know in the chat or via email, and I'll get to you directly. And this training is being co-hosted by the Public Interest Law section of the Florida Bar, or PILS. If you're not familiar with PILS, I highly encourage you to take a look at their website. I will be dropping information about PILS into the chat as well, and it will be included in the email. I saw the email from the bar the other day about its bar it's fee season, so you're gonna start getting those emails soon. And usually, legal aids have the opportunity to select one section. So I highly encourage you to consider the public interest law section. It's probably one of the most affordable sections that's out there, and we have a lot of amazing work groups. So, final piece of housekeeping announcements are questions and answers. We're going to ask you to hold your questions towards the end, and we'll try to get to as many questions if time permits. If we, for whatever reason we run out of time, you can email me questions, and I'll make sure to share those with our speaker. And speaking of our speaker today, I am very happy to introduce you to Courtney Sowerby-Thomas. Courtney is a staff attorney at Florida Rural Legal Services. Sorry, I'm like my notes are okay. Here we go. Courtney focuses in areas of elder abuse and exploitation, housing law, temporary custody law, and foreclosure law. She received her graduate degree from FAMU, her master's in business administration from Nova Southern University, and her law degree from Thomas Cooley Law School. She has been a practicing trial attorney for over 15 years, in which 9 of the years she served as assistant state attorney for Broward County in charge of the elder abuse unit. When she was a prosecutor, she became one of the establishers of the Elder Task Force of Broward County, coordinating random spot checks at nursing homes and assisted living facilities. In addition, she created and developed seminars throughout Broward County focused on scams that affect the elderly, one of which was featured on local 10 news show Leave It to Later, entitled Crash Course Helps Broward County Seniors Avoid Getting Ripped Off. She also developed training for law enforcement in the areas of elder abuse that is still used today. Her passion and drive continue today from outreach opportunities that educate seniors in her community and empower them to no longer be the victims but the victors. And on a personal note, if you've ever attended an in-person conference, in particular, let's say the Consumer and Housing Umbrella Group Conference, otherwise known as SHUG, the first thing that I do is I look for Courtney in the audience because I know I need to pass the mic over to her. She always asks the best questions, the best fact scenarios. So if you ever have the opportunity to reach out to Courtney just to have a 30-minute conversation, I promise you that you will learn a lot. So with all of that said, it is my absolute pleasure to pass it over to Courtney. Courtney, the floor is yours.
Thank you, Jorge. And no, I never have 30 minutes to talk, but on a great break, I will. Thank you guys just for joining. Hopefully, the information that I provide will be helpful in your advocacy. And I give the disclaimer, I'm not an expert, but I do know some things that hopefully will help you in your, focus area of elder exploitation. Elder exploitation is a very important crime that is unfortunately underreported, but significantly affects seniors. As the senior community continues to live longer and basically remain independent, they're becoming more vulnerable to financial fraud, to scams, and exploitation. As advocates, it's critical that we understand what elder exploitation is, the common types of elder exploitation, the civil remedies that are available, the systemic issues preventing effective advocacy, and how we all can basically collaborate with others to overcome these barriers. According to the Department of Justice Elder Justice Initiative, around 10% of older adults, both men and women, experience financial exploitation each year. Older adults with cognitive incapacity suffer significantly greater economic losses than those without such incapacity. Only 1 out of 24 incidents, unfortunately, of financial harm are actually reported to law enforcement. So the consequences include financial loss, hospitalization, and institutionalization as a result. Now, why are these cases underreported? There's many reasons why, and we'll kind of discuss a few of them. Fear of retaliation. The person who is dealing with this exploitation and dealing with the caregiver who has pretty much taken advantage of them has this fear that, you know what, if I say something, that caregiver is going to put me in that back room. There's no windows back there. I'm going to be left alone, to figure it out by myself, and I'm scared they're going to get back at me. Sometimes the retaliation could be that they're not providing them the meals that they need, their basic necessities. And it can also include them not taking them to medical appointments. So a vulnerable adult, an elderly person will feel like I'm not saying anything because my entire life could be totally turned upside down if I do. Fear of institutionalization. I hear that a lot with clients. My son or my nephew or my sister who's caring for me will place me in a nursing home if I say something. And it's that fear that this home that I, paid for, that was my safe place, is going to be taken away from me because I decided to say something about the exploitation. In addition, blaming themselves. They'll say, I should have been more careful with my finances. Why didn't I check my credit report? Why did I even trust that person? Also, physical and or cognitive impairments. We, hear this often. Physically, I need a wheelchair, or I need a cane, or I need some assistance in my movements. And so I need this caregiver. And if I report, a crime against them, who's going to help me to move around my home? Who's going to help me to, function? And as well, the cognitive impairments. A lot of the vulnerable adults, the elderly, don't even recall some of the things that have happened to them. They are either suffering from dementia, Alzheimer's, or some other mental health problem, and they could not express to you what they're actually, seeing happen with their money. They know something's wrong. They know the money's not the same, but they can't eloquently tell you it was that person or it happened on this date. So that also is a reason why they're underreported. Also, I mentioned a little bit about the dependency on the offender. Oftentimes the offenders are family members, or even it could be a caregiving uh, person that's through like a service provider. And oftentimes there is that dependency that, look, this is the only person that I have. I don't have any family that lives here. Maybe, that elderly person has an indifferent relationship with their sister, and that person's not helping them. And so everything that they do, their functions, their eating, their going to medical appointments, their making sure they pay their bills on time, is relied upon on the offender. And so that's another reason why they don't want to make waves. They do not want to interrupt their ability to be cared for if they say something. And then lastly, shame and embarrassment. I've heard clients say, look, I went to, school. I had a college degree. I had a doctorate. How in the world did I fall for this scam? Like, it's impossible that I would be the one to fall for that. And so out of, embarrassment, that the fact that they could be the one, and that they could even trust someone to take advantage of them, is a huge reason why they're underreported. Because to be defined as a victim when you have always been a responsible person is hard to swallow. And so a lot of elderly people feel that it is best for me to just take the loss, deal with this on my own, and not be, embarrassed or even feeling shame that I, the educated person, could possibly fall for this. Now, what is elder exploitation? It is the intent to temporarily or permanently deprive the exploited person of the use, benefit, or possession of the funds, assets, or property, or to benefit someone other than the exploited person by a person who knows or reasonably should know that the exploited person lacks the capacity to consent, Or it can be a breach of a fiduciary duty to an exploited person by their guardian, trustee, who is an individual, or agent under a power of attorney. And it can also be the misappropriating, misusing, or transferring without authorization money belonging to the vulnerable adult from an account in which that person placed the funds, owned the funds, and was the sole contributor or payee of the funds. As it relates to this one, it only applies to personal and convenience accounts and joint accounts created for the sole benefit of that vulnerable adult. So that particular part of the statute. And then it's the failure to use the vulnerable adult's income and assets for the necessities required for their support and maintenance by a caregiver or person in a position of trust and confidence. And so this is what elder exploitation is. Now, who are our common perpetrators in this? Well, the first set are strangers. We've all seen cases come in about the solar panel salespeople who come in and convince the entire elderly community to buy these ridiculous packages that place their fixed income in jeopardy and ultimately have them, not being able to cancel properly, not even knowing what package they signed up for, and ultimately locking them into something that they cannot afford. And so you see a lot of those type of cases. You see the elderly person saying, "Hey, I didn't even get a chance to cancel it, or I didn't even know what I was signing up for." And all of a sudden, that wonderful solar panel salesperson has disappeared into the atmosphere. You also see the lottery scams. We used to see this a lot more, the lottery scams, the romance scams, the IRS scam. And also recently, I've noticed the SunPass scam. And that one comes through your text messages, which I think a lot of you all have received. And it ultimately says there is an urgent need for you to do this action right now. And if you don't, penalty, penalty, penalty. And so that is a very common scam that I've seen myself. And also the AC home repair scam. I started getting cases where the elderly person says, "I called because my AC went out. I was hot. I didn't want to die in here." And the salesperson, showed me pictures of an AC unit and signed me up for a package. And I, of course, didn't want to be hot. So I signed up for it, didn't really understand the fine print. He told me what he needed to say, and I believed it because I was hot. And then ultimately, the person finds out later that the pictures weren't even their air conditioning. It's an air conditioning unit that belonged to somebody else. And so you have scams like that. You have packages being presented by these strangers, and ultimately to lock the elderly person into getting into a package or a program that they cannot afford. As well, you have your professionals, your paid caregivers, your accountants, your financial planners, and your guardians, which we see the paid caregivers all the time doing this. And then, of course, the family members, which are the largest culprits. So you're dealing with, the persons who are supposedly your loved ones, providing care for you and taking advantage of you at the same time. Quick claim deeds are used a lot to do this, the transferring of the property from, that elderly person to the caregiver, naming that, caregiver onto accounts, and then of course using undue influence. So all of these are common perpetrators, and I would say the family members is the largest category. Now, there's a lot of civil theft remedies that are available, and as it relates to trying to fight, against the elder exploitation, and that's Florida Statute 772.11, and it states that any person who proves by clear and convincing evidence that he or she has been injured in any fashion by reason of any violation of the elder exploitation statute, which is 825.103 subsection 1, has a cause of action for threefold the actual damages sustained, and in any such action is entitled to minimum damages in the amount of $200 and reasonable attorney fees and court costs in the trial and appellate courts. Oftentimes, you see this civil theft remedy in situations where people have stolen from Target or Walmart, and the Walmart or Target will send that person a letter that basically says, "Look, you owe us, the value of these products. And if you don't pay it, then we can, seek more damages." On this side, when it comes to the elder exploitation, as long as you can prove that elder exploitation has occurred, you can use this to be able to ask for actual damages and an amount that is even actually higher than, of course, $200, which makes more sense on this end. Now, To be able to actually file under 772.11, you have to make sure that the person who's claiming the injury has made a written demand for the 200 or the trouble damage amount of the person liable for damages under this section. So it's an or. You see it in the context of stores doing the 200 or less because probably the clothes and the stuff that were stolen were not as high value. But when you're talking about somebody's property and land, you're going for the trouble damages. If the person to whom a written demand is made complies with that demand within 30 days after receipt of the demand, that person shall be given a written release from further civil liability for the specific acts of theft or exploitation by the person making the written demand. So it is required that you do a written demand and give them the opportunity to make good. In addition, on this particular statute, punitive damages cannot be collected, but attorney fees and costs are recoverable. So we do like that. Now, I'm showing you an example of a civil theft demand letter that I did as a part of my firm. And this particular letter was sent to a defendant in my case. And in my case, the client had a very close relationship with his nephew, whom he trusted and never, because you never do, suspected him of wrongdoing. The client expressed his desire to leave the nephew his home and land after he died, but the nephew, out of greed, instead convinced him to quitclaim deed the property to him and my client equally. And then he got real fancy. And then he used the second page of the signed deeds to create two new forged deeds, transferring the property and land only to himself. So now my client is considered to be a renter instead of an owner of property. I filed a quiet title action and also did a forged deed and sent this particular demand letter to go after the nephew under 772.11. Unfortunately, my client did pass away before seeing the final result, but this is pretty much the format of the demand letter that you would need to send before you actually would file in court. And in my case, because it related to land, I was able to get a real estate agent to help by providing the specs on the property. And I used that to be able to determine what the value was. And then ultimately, if he had not paid, the trouble would be 1 million plus, plus, plus. Now, another civil remedy is 415.111. You see this used mainly with adult protective services because adult protective services is required to do an investigation under this statute to determine any indicator, of abuse, neglect, self-neglect, or exploitation, if it exists, and assess the safety and risk of further harm, determine the need for services, and make referrals. So you often see this agency using this particular remedy more than anyone. And it basically says a vulnerable adult who has been abused, neglected, or exploited has a cause of action against any perpetrator and may recover actual and punitive damages for such abuse, neglect, or exploitation. Under this statute in particular, the person can be 18 years of age or older, and their ability to perform normal activities of daily living or to provide for his or own care or protection is impaired due to mental, emotional, sensory, and all of the plethora of things, as well as it could be developmental disabilities or brain damage. Now, the cause of action under this statute may be brought by the vulnerable adult themselves or their guardian. It can be brought by a person or organization acting on behalf of the vulnerable adult with the consent of that person or that person's guardian. Or it can also be brought by the personal representative of the estate of a deceased victim without regard to whether the cause of death resulted from the abuse, neglect, or exploitation. Some other remedies, unlawful detainer under 82.035. It says means possessing real property, even if the possession is temporary or applies only to a portion of the real property without the consent of a person entitled to possession of the real property or after the withdrawal of consent by such person. I've had a lot of cases dealing with this where the elderly person allows for their son or daughter to live with them. And in my case, the situation was that they initially gave that permission, but then the son ended up which we find out later had an addiction problem, started using drugs and bringing prostitutes in the home. And ultimately, because of that, they wanted that son and, of course, the prostitutes out of there. And so we, of course, sought out a remedy under the unlawful detainer to remove the son to allow it to be safe for the elderly person, the vulnerable adult, to be there because they had terrorized the home. Everything was a mess and they just didn't feel safe anymore. You can also use an ejectment, which is under 66.021. A person with a superior right to possession of real property may maintain an action of ejectment to recover possession of the property, and you can recover damages and costs under that. And then lastly, the quiet title action, which is what I did, 65.061. It's a legal proceeding to resolve disputes over real property ownership and remove any clouds of title, such as conflicting claims, defective deeds, or adverse possession. So I used this one, and that was why it was connected to that civil demand letter. But I use this to be able to provide clear title showing that my client was the true owner and that the nephew had fraudulently transferred those properties using the quitclaim deeds. Now, a remedy that we often see in our practice is probably the injunction for protection. But I do note that we are more used to the domestic side of it. But there is in law the injunction for protection against exploitation of vulnerable adults under 825.1035. The requirements are that the vulnerable adult includes a person who are or may be exploited. So it doesn't have to be that they are currently, but they may. There's an anticipation that they could be exploited. This statute requires 65 years of age or older. So it's unlike the other civil remedy where it was 18 or older under 415. And then an impaired ability to perform normal activities of daily living. So normal activities for an elderly person, can they feed themselves? Can they dress themselves, bathe, groom themselves? And it also could mean, do they have a disability, mental, emotional, sensory, that is affecting their ability to live a normal life? And so that also qualifies under this statute. And then providing for their own care or protection. So they must be able to do that. And no minimum requirement of residency to petition this. So it doesn't matter how long they have been in that particular county or in the state of Florida, no minimum requirement. And then ultimately, you get to who can bring it. In a temporary injunction, many people can bring it, including the victim themselves. The vulnerable adult in imminent danger of being exploited can bring the temporary injunction. Their guardian can do it. As well, a person or organization acting on behalf of the vulnerable adult can also, or the guardian themselves. An agent under a valid, and I use the word valid durable power of attorney with authority specifically granted because we've seen a lot of durable power of attorneys that don't give the permission that we want, but definitely an agent under one. And you can always, of course, draft that if that is something that your client wants you to do to, of course, get rid of any other power of attorneys that were not maybe drafted properly. But an agent can do so under this. As well, a person who simultaneously files a petition for determination of incapacity and appointment of an emergency temporary guardian of that vulnerable adult. Now, what are the legal requirements for this petition to be able to get the temporary injunction and then ultimately get to the final hearing? Well, the petitioner is your victim. This is your client who has been abused. Your respondent is the abuser. The petition is going to detail the demographic and biographic information of the respondent, the abuser, and it's going to outline the alleged abuser's offenses. What did they do? What is the exploitation that has occurred or going to occur? And ultimately, what evidence do you have in support of the allegations? Now, an on duty judge will end up reviewing your petition, and it is important that it is sworn to. And so the document does require to be sworn to under penalty of perjury. And the judge is going to ultimately look at it and make sure all the information is there. They can identify who it is. They can identify, what type of exploitation has occurred, what you're seeking, what proof you have, and they're going to go ahead and hopefully, grant the temporary injunction. And within 15 days, you're going to get the temporary injunction, of course, and you're going to get a future date for the final hearing. And when that final hearing is set, if the other side, the abuser, is not represented by an attorney, they, of course, will have an opportunity to come to court and ultimately say, Judge, I need a continuance because I don't have an attorney. I'm just becoming aware of this. Or it will proceed on that day, like a mini trial, like any other injunction. Now, as it relates to filing it, there, of course, is the same thing for domestic. There's no requirement that the abuser be aware that a temporary injunction has actually been filed. They don't get the original notice of that temporary. There's no filing fee. You actually don't even need us, the attorneys, to be involved, but I think it is better because it's a little bit more intimidating. And then, of course, it can be filed in the circuit where the vulnerable adult resides, or if there's a pending guardianship, it can be filed in that proceeding as well. So, if the court does grant this injunction, meaning they have gone through the process and they see through a final hearing, you're good to go, you've proven your elements. What they're basically looking for is, have they been exploited? Or is there imminent danger of them being exploited? And is there a likelihood of irreparable harm and non availability of adequate remedy at law? And substantial likelihood of success on the merits, and there's a threatened injury to the elderly or disabled adult that outweighs the possible harm to the respondent. So respondent might come in there and say, oh, it's not fair, I didn't do this, I didn't do that. As long as these elements are met, you are good to go. Temporary injunction is pretty much granted, and you are proceeding to put on your case, your evidence, and to get that final disposition that ultimately says that the injunction has been granted. Now, what kind of relief can you get after the evidentiary hearing? The court can prohibit the contact with the vulnerable adult. So basically letting the abuser know you are to have no contact. They can restrain the abuser, the respondent, from further exploitation. They can award the vulnerable adult temporary exclusive use and possession of the dwelling if that's what's in question, that's shared, or barring the respondent from the home. They can also freeze any assets or credit lines of the vulnerable adult, which also the banks can do. And I always encourage, my clients, let the banks know you are a victim of exploitation. You want your accounts to be frozen, but for your SSI clients and for persons who are on fixed income, ask for that money to be moved into a separate account so that they can still pay their bills. And you can put that in the petition as well, so that the court is not requiring that all the accounts are frozen. You want to say, Your Honor, can we keep this one open because we do have bills that are paid and there is a direct deposit that needs to go into that account. As well, they can order the respondent to participate in treatment and, of course, directing assets to be returned to the vulnerable adult or remain frozen until ownership can be determined. So, in situations where you have maybe another civil action pending, they can at least direct that everything remains frozen until that pending action has kind of resolved itself. Order respondent to pay costs, provide directives to law enforcement, and order any other relief if necessary to protect the vulnerable adult. So there's a lot of things that you can get out of doing an injunction and, of course, making it to a final evidentiary hearing. Now, housing law, probate law, and consumer law are areas of law that truly intersect with elder exploitation, and they highlight similar vulnerabilities that exist in the elderly community that make them more susceptible to exploitation. And it affects their ability to remain housed, leave assets for their beneficiaries, and make them more likely to fall prey to scams. In housing law, elder exploitation, as you all know, can lead to the eviction of an elderly tenant who can no longer pay their rent. It can lead to a foreclosure of their home due to failure to pay their mortgage or their property taxes. According to the American Bar Association, the elder abuse, can lead to homelessness. And conversely, living in unsafe or exploitive housing environments increases their vulnerability to scams and financial loss. In probate law, elder exploitation can occur when a caregiver or like a trusted friend convinces the vulnerable adult to change their will, naming the caregiver instead of the original beneficiaries. Or the caregiver can convince the vulnerable adult to transfer large funds of their savings to them. Or the caregiver can convince the vulnerable adult to quit claim deed property outside of the will, which is what happened in my case, where my client thought, I'm preparing my will before I die, and I want my assets to go to my beneficiaries, which did include the perpetrator. But instead, the perpetrator convinced him, we don't need to worry about that. Well, we're just going to sneak this quick claim deed in there. It doesn't come into action until you die, which is all lies. And ultimately, I'm going to steal your property. And that's what he did. In consumer law, elder exploitation can occur when a business such as solar panel businesses or businesses make false or misleading claims about what it sells and the type of plans that they offer. This, of course, reveals that there's some hidden mandatory fees that the elderly person was never made aware of, was not somewhere that you can actually read it. Because remember, we're talking about the elderly community. Most of these people either use glasses or some kind of, extra assistance. And I'm sure on those wonderful contracts, it's in very, very tiny, tiny print. So you need a magnifying glass to even see it. But it's even worse when you have an elderly person trying to go through a contract. So they usually just trust what the salesperson is saying. And then it's also unclear as it relates to canceling the contract. How do they do that? And so ultimately, all of these areas of law end up, intersecting and causing more problems for the elderly person because they're being exploited in so many different ways. It's kind of like hard to figure out where do I even begin to like find relief. Now, one of the most important parts and one of the things that we deal with as advocates is that client intake and the interaction with the clients, and the trauma informed approach. It's important that we understand that the process of ensuring that our clients are not re traumatized or feel that we're not listening is addressed. We want to be sensitive. We want to make sure that we are listening and aware of what their needs are. So, some of the things that I think are important when you're interviewing the client is interview away from the perpetrator. Yes, it sounds very obvious, but usually we're talking first time with our clients on the phone. Always check to make sure that the perpetrator is not home with them. Make sure that they are in a safe place to even have the conversation with you because you're about to ask them very intimate and sometimes very factual information, and if the perpetrator's in the other room, you're going to get a lot of whispering and uncomfortability from your elderly clients. So just make sure that you ask, are you alone? Are you in a safe place? Is this a good time for me to talk to you? Do they have a present or immediate fear? I've had clients come through where they're like, yes, I was exploited, several years ago. I'm just, really scared to be exploited again. Well, it's kind of general. There's nothing that really says that there's the perpetrator is living with them or the perpetrator is coming back to live with them or there's some indication that they could be exploited again. Just be mindful to just ask, are they presently being exploited? Is there truly an immediate fear? Or is this one of those cases where you're like, I'm going to monitor it. I'm going to see what's going on, keep in touch with the client, and then, of course, follow up to see if this is something you actually need to look into. What languages are spoken? This is important, of course, in your many conversations you're going to have with them in the office or by the phone. But it's even more important when you go to court. You got to know if this person is more comfortable speaking in Spanish with an interpreter or Creole or any other language. And you want to have that interpreter in place. You don't want to get to court. You got everything right, except you forgot that your client cannot understand you that well and is not going to be able to effectively convince the judge that this remedy needs to be granted on their behalf. Also, are they comfortable testifying in court? I've had clients tell me, yes, I've been exploited. Yes, my money was taken. I am devastated. I've been a victim. All the things you want to hear to get like those juices of advocacy going. And then they say, oh, but I don't want to testify in court. And you're like, are you serious? Well, it's their right. It's not yours. So you want to ask the question, are you comfortable sitting in a courtroom and having to confront the person who has exploited you? What could I do to make it more comfortable in the most reasonable way I can and what the court allows? But are you even comfortable going to testify? You have to ask the question. You don't want to do all this work to ultimately for them to say, I won't be showing up to court. I'm not doing it. I will not confront them. I will not go in front of a judge. I'm scared and you can't convince me. A different remedy might be a better way than to do maybe the injunction, or maybe you can do a quiet title action if that's applicable. And, you just kind of need to look at the other civil remedies. But an injunction probably is not going to be the best if they're not willing to go to court. What are the transportation needs? What are their needs in regards to glasses, hearing aids? Are you going to have to make sure you have transportation already planned for them to get to court? Do they have a neighbor that can drive them? Do they need glasses, to be able to read? Here you are in court showing them evidence, and they don't even know what you're showing them because they didn't bring their glasses. Make sure you know that they use glasses to read documents. Make sure you know if they have hearing aids to be able to properly understand your questions. It's very embarrassing to have to say, I'm going to repeat it louder because I, we don't need to do that in court. Ask the questions, be prepared, know what your client needs. As well, mobility aids, do they have a wheelchair? Do they use canes? Do they have anything that's going to prevent them from, let's say, stepping up on the witness stand? You can ask the court, Your Honor, can my clients sit in a spot in front of the witness stand? They can't get up that way. That's going to cause them pain. Know these things in advance. And ask simple and clear questions. When you're interviewing them, you're asking, hey, did such and such take your money? Did they take that money from your wallet? Did you see them take it? How did you know that it was that much? Did you read something? Just ask the simple questions and let them talk. They want to talk anyway. Let them talk. Ask, for clarifying, information after, but just be simple. When you went to the bank, was your money in there? It was gone. Well, what did you do next? Simple and clear questions. Also, previous calls against a suspect. Have they ever called Adult Protective Services? Have they called the police? This is important because if there are any documents that are going to help build your case stronger, help you to have better evidence, be able to get better witnesses, you want to know if this exists. Now, maintaining a normal client-lawyer relationship with clients with diminished capacity is also an issue that you will encounter and is important per the professional ethics rule under 4-1.14. And it says, when a client's ability to make adequately considered decisions in connection with the representation is impaired, whether because of minority, mental disability, or for some other reason, the lawyer shall, as far as reasonably possible, maintain a normal client-lawyer relationship with the client. If there is evidence that the client is at risk of substantial physical, financial, or other harm, they can consult with others. And in doing so, a lawyer may seek the appointment of a guardian. If no guardian exists or legal representative exists, the lawyer must act as if they were a guardian. And the fact that the client suffers from a disability does not eliminate their obligation to treat the client with attention and respect. The client is still the client, and communication should still take place. I get a lot of cases like this where there is clearly dementia, Alzheimer's that exists, but I make sure I'm clear. Is there a guardian? Is there a power of attorney? Is there something that they can understand? Maybe, brief conversations with them. You want to take good notes. You want to make sure you are still showing the respect to them because they're still your client. And you're going to see later on in the video that they can still testify on their own behalf on the simplest things of, did you give permission? Now, evidence gathering. When a client or a guardian comes to your firm seeking help for elder abuse, neglect, or even or exploitation, it's critical that you investigate thoroughly to ensure that you have enough evidence to determine the cause of action you want to file, and of course, enough evidence to prove the actions. So you may want to know, what is the relationship between the perpetrator and your client? Identify the money or property that's been stolen or compromised. What is the location and account numbers of any of the compromised or fraudulent accounts? The address and location of any of the compromised real property. Supporting documents to prove ownership. If legal documents, is there a POA? Is there a letter of guardianship, deeds, trust? What's involved and how can you obtain them? Are there signs or diagnosis indicating that your client suffers from dementia or Alzheimer's disease? And how long have they been dealing with that? And is your client under the care of a doctor or specialist? So I think these are, like your basic good questions to ask as you're relating to your client and trying to ultimately gather enough evidence to figure out what civil remedy you want to undertake. Now, collaboration with other agencies is extremely important because, of course, no single agency, no professional can effectively do this advocacy by themselves. And so, collaboration is key. So, who can you collaborate with? Well, the banks. You can request financial records and have the vulnerable adult identify the fraudulent charges. You can request a freeze on accounts and notate that they are an exploited victim. And so they can move any SSI or any other fixed income to a new account or bill paying. You can also collaborate with medical facilities by requesting the vulnerable adult provide any medical documents that prove impaired ability to perform normal activities of daily living or diminished capacity. Of course, HIPAA is involved, so you want to get your client to immediately try and obtain this documentation. And as well, the local police, you can request any reports on financial or domestic abuse and notate police observations. I've had, officers subpoenaed to testify if they have made very good notations in the report regarding the exploitation. You can also call DCF, Adult Protective Services. DCF investigates filed injunctions per court order. That happens in our particular county. And you can, inquire about what they found when they visited your client. What did they find was going on or wrong that might be different than your report. They have their own investigators and they will have a very thorough report to provide to the court. And you have the right to also review that to be able to know if they are disagreeing with your assessment, if they have additional, persons that maybe your client didn't mention that you can also add to the petition. They can request a complete file on the vulnerable adult, so you can request that. And they offer protective supervision and intervention and community and home care for disabled adults. So if that's applicable, Adult Protective Services or Department of Children and Families can provide that. As well, the Florida Long-Term Care Ombudsman Program. It's a federally and state mandated program administratively housed within the Department of Elder Affairs. They have trained staff members and volunteers that can identify, investigate, and resolve health, safety, welfare, and rights of residents at nursing homes, ALFs, and adult family care homes. And they assist with discharges and evictions. They assist with medical administration and other things. I worked very closely with these agencies when I was a prosecutor. But on the civil side, they are also very helpful because they can provide additional details that you're missing, names of perpetrators, documented complaints, and insights on how your client is feeling throughout the process. Because ultimately, they're the ones that are going to have a lot more interaction than you may on the day to day. And so use them, collaborate with them, see if they can offer assistance or even be a witness in helping you to get your civil remedy granted. Now, there have been various legislative actions aimed at elder exploitation, but despite these efforts, policy changes and funding have been dismal. Systemic issues in elder exploitation include inadequate funding, lack of comprehensive legislation, and insufficient client data-driven solutions. The National Collaboratory to Address Elder Mistreatment, NCAEM, was established in 2016, and it's aimed at improving the identification, intervention, and prevention of elder mistreatment through innovative models and a mentorship program. Every year, these experts convene, and they are, researchers, policymakers, federal and state agencies, and their goal is to develop strategies for accelerating policy action to address elder mistreatment. This particular collaboratory expresses the need for central messaging to accelerate the funding and impact for this particular field. And they address the need for a unified and stronger infrastructure and messaging. And they also focus on the importance of data-driven policy and evidence-informed prevention and intervention practices and expanding strategic engagement. So I was very impressed by, this particular group because they really get to the heart of how we can change it from the legislative side all the way down to every particular person who is involved in interacting with the elderly. Now, what are the avenues available for effective advocacy? You can do outreach at, ALFs, nursing homes, and senior housing, identifying and supporting policies in various fields that may indirectly impact elder mistreatment, such as mental health, family support, dementia care, establishing relationships with various advocates to foster cross-sector collaboration. Utilizing data to demonstrate outcomes and impact is critical to deriving policy change. And then, of course, improving engagement with efforts to address caregiving challenges, social isolation, and family violence. I know that as attorneys, we're not, social workers, but we end up playing that role. And having proper resources, knowing who is out there also in the fight to, protect the elderly from exploitation really does help to hopefully advocate better and hopefully bring these cases, to the attention of, the local courts and to hopefully stop a lot of the exploitation that's been happening. I want to now end with two videos provided by the Elder Justice Initiative that focus on financial exploitation by a stranger and by a family member. And then I'll talk about some highlights of each video.
One day, my uncle called me and he said he needed some money, some bonds. So, without question, it's his. I gave it to him, and it was a significant amount of money. And 3 weeks later, he called me up and he said he needed more. And I go, "What are you using this for?"
Misty McKinley found Roger Waller, we think, at a gas station. We think she simply saw an easy target. She asked him for a small amount of money. He gave it to her. Somehow she found out where Mr. Waller lives, and she proceeded to go to his home, and she would ask him for money. She would ask him for rides.
Misty McKinley was the type of person that she preyed on people like that. She looked for opportunity, people that she could manipulate and take advantage of.
On a few occasions, Misty McKinley had Mr. Waller drive her to the gas station, and when they got there, she'd have him fill up her boyfriend's car with gas. And that made Mr. Waller very uncomfortable, but he didn't know how to say no.
She would come around, she would knock on the door, and after my insistence of him not answering the door, she started to knock on the windows. When she would show up here, bugging you, what did that feel like to you? When she was knocking on the windows?
She knocked on the window here.
Yeah. How'd that make you feel?
I didn't like that at all.
His train of thought was, if I just give her what she wants, she'll go away. Well, we obviously know that that's not the greatest idea. So I put a surveillance camera up so I could see when she was coming, what times of day she was coming. I could see 2 in the morning, I could see 4 in the morning. One day, she had walked around the house for an hour, knocking on windows and doors.
What are you doing here?
Mr. Waller told her he didn't want her to come to his home anymore. He felt intimidated. He was starting to feel scared because she simply wouldn't stay away.
I noticed he became quieter. He just seemed way more reserved than normal, lost weight.
Mr. Waller's family actually caught her in the act of coming over and knocking on his door. Despite numerous requests to stay away from the home, she kept coming back. So they got a restraining order.
She knew she was taking from somebody who didn't have anything to give her and kept coming back and back and back and back and would not go away.
The first time Misty was charged, she was charged with a couple counts of violating the harassment restraining order.
She was caught once, she went to court once, pled guilty once, and they let her go. And when they were supposed to bring her back for sentencing, she never showed up.
It was really difficult because she would come at all hours of the day, and then she was gone so quickly. And so it took a long time before we were ultimately able to take her into custody.
As we were building evidence for the case, specifically looking at the financial exploitation, it ultimately came down to evidence of what we could prove in court.
In this case, because it was small amounts of cash over a long period of time with really no record kept, we just didn't have enough evidence to establish the amount necessary for a felony level financial exploitation case. The most serious offense that we had was a stalking offense, and so that's the one I charged. I will say that as part of her sentencing, it was important that she be required to pay back some of the money. I was happy with the outcome of the case. She was terrorizing him. At one point, he told the investigator that he felt like a prisoner in his own home, and stopping that was really our number one priority.
How are you feeling now that she is no longer...
Oh, I feel good about it.
You feel good? You're feeling a little bit more like yourself?
Yeah.
When you walk through this neighborhood, they know who Roger Waller is. He's known in his community. And for somebody to be known in their community, loved in their community, to be taken advantage in their community, to be made to feel like they're not safe is not okay.
So this video highlights the signs of exploitation by pointing out how the perpetrator used the kindness of the vulnerable adult to take advantage of him. The perpetrator started off asking for small amounts of money that appeared to be really not a big deal, and then that increased to larger ones, but all in cash. So there was no way to properly track this, of course, and it was, of course, still being given. This video also highlights how even though the vulnerable adult was from that community, known in his community, he still felt that he no longer had any right to say no to her, and he became reserved and felt like a prisoner in his own home.
Patricia King was a widow who was living alone in East Palo Alto. She was diagnosed with dementia. Miss King was 88 years old in 2008 when her niece, Miss Remmert, moved in with her. It was helpful to her at the outset to have her niece living with her because it was somebody to help her out around the house and keep her company. What she started to do was slowly consolidate her aunt's financial accounts, and she also had her aunt sign a quitclaim deed to her home, transferring ownership of the home from Miss King to Miss Remmert, the offender. Miss Remmert's cousins were becoming increasingly concerned about their aunt because of the isolation of Miss King that Miss Remmert was imposing. She was making it increasingly difficult for family members to come and visit.
Shirley began to isolate my aunt by becoming more limiting of the family and also of her friends and church members of coming to see my Aunt Pat.
Shirley Remmert had changed the locks on the exterior fence surrounding the home and had changed the locks on the home itself. So family members could no longer gain access to the home.
I had called my aunt and I let her know that I was coming.
I called the police.
Okay, all I want to do is see Auntie Pat.
I don't care.
And Shirley called the police and asked that the police remove me from the house.
There were multiple parties that made reports to Adult Protective Services expressing concern about Miss King's welfare. One of the reports came from the bank where she had a checking account. She went to the bank on 4 occasions and she made 4 $10,000 withdrawals. The amount of those withdrawals combined with how close in time they all were caught the bank's attention, and Bank of America made a report to Adult Protective Services that these were suspicious transactions on an elder's account and asked Adult Protective Services to look into them.
A social worker who's described as a deputy public guardian who does just financial abuse cases became involved in the case because of the financial allegations.
They phoned Miss Remmert in advance and they made arrangements to meet up with her, with Miss Remmert, at Miss King's house. The deputy public guardian made the decision to reach out to the East Palo Alto Police Department and ask them please to send an officer as a civil standby to simply provide safety and make sure that things at the home went as smoothly as possible.
She kind of gave me a brief of who she was going to talk to and why she was going to talk to her. I knew we had something a little more than just a civil standby. She had some substantial evidence and information.
When they went to the residence, they found Shirley there with Aunt Pat. The deputy public guardian had a very pointed and direct conversation with Shirley about the nature of the financial improprieties that they were aware of based on Pat's financial documents. And Shirley was taken aback, to say the least.
Miss Remmert was nervous, she was inconsistent. At that point, she threw her hands up and said, I liquidated the money.
What?
It's in my room. And at that point, I escorted her to her bedroom. She then pulled out a box of money. In the end, after counting, it was about $80,400. Due to Miss Remmert's inconsistencies with her answers, and finally showing us the money that she did liquidate, I arrested her.
Most financial elder abuse investigations are complex, and we generally advise law enforcement to gather their evidence and then consult with the district attorney's office to see what the next steps are before taking a suspect into custody. But in this particular case, the fact that the quick-thinking East Palo Alto Police Department apprehended Ms. Remmert on the spot was crucial to our ability to not only preserve the cash that was seized from the home, but also to freeze the home and execute a search warrant. And a tremendous amount of crucial documentary evidence was discovered. This document over here, it says quit claim deed. When you signed this, did you believe that you were giving away your house?
Oh no, I'm not giving away my house.
The fact that the victim of a crime has dementia shouldn't necessarily indicate to you that that person cannot be a witness, and an important witness in their own case. Do you want to continue to own your house until you die?
When I die, my people divide my house.
These are the kinds of cases that are nuanced. They typically involve very complex family dynamics that have taken decades to evolve and are only getting worse as time progresses. So if there's history with that family, Adult Protective Services will be able to provide that to you while you're in the field. And that situation that's in front of you that you're looking at is going to look really different through the lens of all of that information than it does when you're just standing on the porch with someone trying to figure out whose paperwork is more legitimate than whose.
At the end of the jury trial, Ms. Remmert was convicted of multiple felonies, and the trial judge sentenced her to 7 years and 4 months in the Department of Corrections and Rehabilitation. The cash that had been seized from the home was released back to the victim, and the judge signed an order voiding the deed and returning Ms. King's home to its rightful owner.
So this video highlights the signs of exploitation by pointing out how the niece took advantage of the widowed adult who lived alone and began to slowly consolidate her aunt's accounts without her knowledge, used a quitclaim deed to quickly transfer the property, isolated the vulnerable adult from family by limiting visits from those who cared about her, changed the locks on the entry doors, preventing outsiders from coming in and helping. And this video also goes back to the professional ethics rule 4-1.14 and the importance of treating your clients who suffer from dementia or Alzheimer's with respect, and that even if they can, even they, can be an active participant in their own case and be able to effectively testify in court to successfully get the court to grant the injunction. So final thoughts, preventing elder exploitation is a large task, and it does take being sensitive to your clients, listening, documenting, identifying the appropriate civil remedies, collaborating with other agencies, and basically educating our elderly communities about the types of exploitation and how they can be more vigilant in protecting themselves. We all play a critical role, so I encourage each of you to be willing to go the extra mile and advocate for those in this vulnerable community, because the payoff is one less vulnerable adult being further exploited, and of course the peace of mind that they have, that they don't have to worry about losing their life savings. And I have some resources, and that's it.
Courtney, you are a real life superhero. I'm just saying, this was an amazing presentation, and the work you do is amazing. I know we still have a few minutes left, and we have a few questions that I want to make sure they are addressed. I'm going to drop the CLE code in the chat. This is all going to go out via email, and it's also going to be in the YouTube description. The CLE code is 2603871N as in Nancy. So I'm going to go ahead and read the first question that I saw in the comment in the chat. So I'm gonna read them out loud in the order that they came in. So this question is from Boy Ferreira, and the question is, it's a long question, so bear with me. Can temporary homelessness caused by a disaster qualify a person age 60 or older as vulnerable, even if the person did not have age-related infirmities, organic brain damage, or other physical, mental, or emotional dysfunction before the disaster, where the disaster has impaired the person's ability to provide adequately for their own care or protection? For example, The person may be unable to perform activities of daily living, including ambulation, bathing, dressing, eating, grooming, toileting, and similar tasks. The person may also be unable to meaningfully consent to certain financial agreements and lacking equal bargaining power because of disaster-related homelessness. And if you agree, is there any authority supporting this position?
So, yes, I do agree that homelessness in that just full context does apply to 825 103 because you're talking about them not being able to care for themselves. I mean, you gave very specific things, but homelessness also relates to mental health. And so you have persons who are homeless who either due to the homelessness or what caused it end up not being able to function properly, deal with their finances, can't bathe, can't groom, can't do anything. Well, those are normal activities of daily living that they are unable to do. So I believe the temporary injunction, if there's a situation where there's someone who has caused that, you can always use. And then ultimately, if there has been a situation where someone's taken advantage of that person, due to the homelessness, you can try, to go with other civil remedies, the 415, or if it's a land dispute, you can deal with, of course, the quiet title. But since you said homelessness, I don't think that one necessarily applies. But I do think that you have quite a few. You just need to have a perpetrator. So I'm going to assume in all these situations, a perpetrator is involved because you do have to, of course, have an abuser or someone on the other side that you're bringing the civil remedy against. And I'm sorry if that doesn't answer the question, but
It was a great question, Paul. So here's another question from the Q&A. The question is, what kind of protection do they have after testifying in court from the perpetrator?
well, I mean, ultimately, I've asked for the perpetrator to be immediately, removed from the property. So if they had to come and get their stuff, a police officer would have to be there. I've asked for, if there's if it's a deed situation and I'm going forward on a civil remedy to quiet title the action, that there not be any movement on that property. So a lis pendens can be filed to protect the property, that the perpetrator does not have the right to go and post it on realtor.com and sell the property right under the person. So, I mean, besides your normal stay away and, maybe an unlawful detainer if they're just totally not listening, you want to make sure that you're going forward on other civil remedies and you're asking the court and the injunction to pause any kind of movement, freezing of assets, no movement on that property, and to give your client that temporary right to be there while the other civil remedies are being litigated.
Here's another question from the Q&A. Have you dealt with proving vulnerable adult claims at trial? Under the statute, it seems evidence is always needed of an infirmity or vulnerability that makes the victim unable to take care of themselves. Is there an instance where you have been successful in proving the claim without such evidence? For example, a full functioning elderly person is emotionally impacted by a natural disaster, but they still function independently and do not need assistance with activities of daily living.
Well, I mean, remember if you're dealing with a situation where it's a quiet title action, you don't need all of those things. You just need to be able to prove that someone has taken advantage of them and has exploited them. If you're talking about a temporary injunction, I think when you're old, your normal activities have changed. You're not doing everything the same. And I remember having a client where sound mind, independent, been living, by themselves for forever. But I said to them, I said, but are you moving a lot slower than you normally do? Are you, necessarily needing, to take a little bit more time for your tasks? You can elicit testimony through that particular witness to show that I'm not doing the same things I was doing when I was 40. I'm moving slower. I may need to take some more time. I have to do reading glasses. I'm independent, but I need reading glasses. So all of those things still kind of relate to there have been changes in my ability to function. And I am vulnerable in the sense that I am not that 40-year-old who's going to catch things fast. I am an elderly person by age, and it has affected my ability to do all the things that I used to do. So I think you can elicit that in testimony. I have done that. And though it wasn't the best of evidence, it's still evidence.
I know we're a few minutes over. We have one more question in the chat,
Sure.
and the question is, the ethics slide mentioned that in some circumstances, sorry, it moved up. In some circumstances, the attorney should act as a guardian. Does that mean that in the scenario where the VA has no guardian and the VA does not want to consent Under 825, the attorney may seek to initiate a simultaneous petition to determine capacity in order to obtain standing to seek the protective injunction under the statute.
So I think I understood the question. So it says that if there is evidence that the client is at risk of substantial physical, financial, or other harm, the lawyer may seek the appointment if they don't exist per your question. No one wants to represent them. There's nobody else, and it's just you. It says the lawyer must act as if they were a guardian, or they can go forward and trying to solicit for other services to be able to provide that. So basically what they're saying is you don't get to say that your diminished capacity client is no longer your client and does not have any rights just because we can't find legal representative or a guardian right away. You can do as an attorney and say, for the temporary purposes of getting through this hearing, I'm seeking to be the guardian, or for the purposes of this, I'm seeking ... So it is a must in that you cannot leave them in a place where they are not somewhat represented, even if it is temporary. And so that's how I read this particular rule.
All right, I know we may have a few more questions, but we're out of time. So if we
Okay.
missed your question, feel free to email those any
Yeah.
additional questions to me, and I'll make sure to connect you with Courtney. I wanted to take this opportunity to thank everybody that joined us here today.
Thanks, guys.
And Courtney, thank you so much for taking time out of your very busy schedule to come teach us about this really important topic and a major vulnerable population that we all serve in the legal aid and public interest law community. So thank you all again. Thank you, Courtney,
Bye,
and we'll see
guys.
you at the
Thank
next one.
you. Have a good one.
Bye.